Hello, viewers. My name is Victoria Servant, and today I will be discussing the wrongful conviction journey of Jeremy Puckett. I apologize in advance for any stutters, or small moments of silence as I gather my thoughts. And with that, I shall continue on. Jeremy Puckett is just one of the many wrongfully convicted. Jeremy's story takes place in our very own capital, Sacramento. On March 14, 1998, the body of 19-year-old Anthony Galletti was found along the side of White Rock Road in Rancho Cordova, California. Upon finding his body, it was found that he had sustained gunshot wounds to the back of the head. His hands were tied behind his back, and he had no wallet, keys, money, or identification. And his car was found a few days later, but it had been torched. The case then went cold. However, in 1999, an inmate at a California state prison named Puckett as the shooter, and Puckett, upon following this statement by this informant, was arrested in April 2001 and was later charged with Galletti's murder in September. Moving on to the investigation and the trial. It's important to note that 2 years prior to Puckett's arrest, the inmate, whose name is Israel Sepp, approached a prison guard saying that he had information about Galletti's murder and wanted to negotiate benefits for himself and his family in exchange for information about the case. With this information, prosecutors first charged only Sepp with the murder and robbery of Galletti, since he did admit to being there at the time of the murder. However, after opening statements at his trial, he did plead guilty to the robbery of Galletti and accessory to his murder in exchange for a lesser sentence and a promise to testify against Puckett. And with this statement from this jailhouse informant, the police arrested Puckett and charged him with Galletti's murder. And it's important to note that there was no actual physical evidence tying Puckett to the case. It was solely based on this informant's statement. And then another pivotal point in Puckett's trial, or I should say pre-trial, Sepp recanted his original story, and he told Puckett's defense counsel and the public defender's investigator that he, and along with two other people, which did not include Puckett, had set up Galletti to be robbed at some apartment complex. But this statement never made it to Puckett's trial because he recanted his recantation statement, and at the at the trial, he solely pointed the finger at Puckett, saying that he murdered Galletti. And unfortunately, during the trial, Puckett's trial attorney did not enter the recantation into evidence, so the jury never knew that Sepp had changed his story 2 different times and had implicated others into the scene. So with the lack of physical evidence, but with a supposed strong statement tying Puckett to the scene and as the murder, Puckett was convicted of murder and robbery in a jury trial, and according to the Northern California Innocence Project page, the deliberations lasted almost as long as the trial itself, and on March 14, 2002, Puckett was sentenced to life without the possibility of parole. While Puckett was doing time in prison, he first contacted the Northern California Innocence Project in 2012, and it was at that point when the NCIP uncovered about 700 pages of suppressed materials. And in July 2016, the NICP filed a petition for a writ of habeas corpus at the Sacramento County Superior Court, but it was denied. But they tried again for another petition in the 3rd District Court of Appeal, but it was also denied without an explanation or a hearing. But finally, in September 2017, a petition was filed for a writ of habeas corpus in the California Supreme Court, and it was passed. And based on the lack of physical evidence, as well as the 700 pages of suppressed materials which corroborated Sepp's original recantation, it was found on March 3rd the Superior Court overturned the murder conviction against Puckett, and on March 13th, Puckett was released and the prosecution dropped the charges. I did try to see if Jeremy Puckett had received any kind of compensation, but I couldn't find anything after his release or about anything that what he was doing. But I do know that there are clips about Jeremy Puckett's case on the internet, so I did see a few of those. So I do advise for you to look it up. It's a really interesting story, unfortunately, that took place. So there were a few causes that contributed to Puckett's wrongful conviction, but I want to focus more particularly on the jailhouse informant as well as the ineffective assistance of counsel. So to begin, one of the main components in Puckett's arrest, which was the basis for his whole case, was the false testimony of a jailhouse informant, Israel Sepp. Now, I know I keep saying jailhouse informant, so what exactly is a jailhouse informant? A jailhouse informant is an incarcerated individual who either hears information about a case from someone else, like say his cellmate or someone within the prison system, or he personally or she personally knows information that is pertinent to a case. However, a jailhouse informant might also be known as a snitch, and it's been known that if you snitch, you're obviously not looking to make friends in the prison system or whoever you snitched on. So that's why it's kind of known that jailhouse informants' testimonies aren't the best piece of information to base a case off of, seeing as that they do have a speculation to lie in order to either receive benefits or a lesser sentence. And in the case of, please forgive me if which I know I will mess up these names, but in the case study of Dolach, Newshots, Westmore, and Bornstein, in their study, they explored the successful detection of a jailhouse informant's possible ulterior motives or discrepancies in their testimony, which would influence verdict decisions. And in this study, it consisted of 384 participants, and all participants were given a trial transcript and then broken into 3 groups, which consisted of course, a trial transcript from a jailhouse informant's testimony. However, the variable in this study was that the jailhouse informant's testimony had been manipulated into containing either an inconsistency, an ulterior motive, or an alternative explanation. And after reading the trial, participants were asked to make a verdict decision and attributions about the jailhouse informant. Once the participants had listened to the transcript and made their decision, it was revealed that inconsistency statements and alternative explanations reduced conviction rates, while those with ulterior motives showed to have actually no effect on the participants' decision. Now, you may be wondering, well, what does this have to do with Puckett's case? So, in the study, the jailhouse informant testimony was the main piece of evidence that was either going to convict or release the accused party. Now, in the context of the research, it's a given factor that all evidence was brought to light and was present during the trial and shown to the jury. However, this study was I would say a good case where everything went as good as it could be. However, in Puckett's case, the opposite happened, and Sepp's ulterior motives were not provided to the jury, so they were left with only half of the story. And unfortunately, they were left with a story that implicated Puckett instead of releasing him. The second factor contributing to Puckett's case is ineffective assistance of counsel. So, a strong piece of evidence that would have helped Puckett was that at the evidentiary hearing, Puckett's sister gave him an alibi stating that Puckett was nowhere near and in the location, in fact, where Galletti was murdered. He was staying at a friend's house after being at a barbecue all day with the family and some friends. And this statement was not brought to the jury, and as well as Puckett's defense lawyer not allowing the indiscrepancies of Sepp's statements where he went back and forth stating that Puckett was there and then he was not there. He did not bring that to the jury's attention. In addition, he didn't cross-examine the prosecution's witnesses either, and did not effectively assist Puckett in proving his innocence. And now, in just discussing these issues, it brings to light that one would say Puckett's defense lawyer was a bad lawyer. And according to Barry, an article that shows what it means to quote unquote be a bad lawyer, one of the main points is to have minimal preparation or a weak trial advocacy, and wouldn't you know it, superficial and or tentative cross-examination, which Puckett's lawyer is guilty of. Since both of these problems have not only occurred in Puckett's case and has occurred in other cases, it must mean that there has to be something that needs to change. So for informant reforms, one of the main ideas that has come to light and is a strong point, in fact, is to allow for both the prosecution and the defense to be able to corroborate the testimony in question before allowing the informant testimony to be used in court proceedings. So if both the prosecution and the defense are able to prove and figure out where this testimony has come from and who is actually informing them, it probably would lower conviction rates, and the jury would be able to see what the testimony has to offer and not only be based off of an ulterior motive, which Sepp had. And it would also be important to note the tracking of the use of the jailhouse witness testimony to see if the jailhouse informant, like where he got his information from and if he's actually connected to the case, and to see if what connections he has throughout the prison and outside of the prison, just to see if for some reason there is a reason to speculate. And for ineffective assistance of counsel reforms, to be honest, I did have a bit of trouble figuring out this one because there aren't many defense attorneys nowadays that want to do work pro bono or to help those who have a murder charge against them. However, those who are defense attorneys, one point of reform would be to provide them with a workable caseload that they are able to go back and actually meet with their clients and understand the details of the crimes they are being accused of. Also, according to Bernhard, taking a point from his excerpt from Wrongfully Convicted Perspectives on Failed Justice, it would be smart to provide a secondary review of the case, either by another defense attorney, peer, or another special group dedicated to making sure that each case is being upheld to its utmost standards in order to provide what we the people want, which is fair and dedicated counsel. And that concludes my discussion on the wrongful conviction journey of Jeremy Puckett. I know my presentation definitely went over. Yeah, no, sorry about that. My audio cut off, but I know my whole presentation went about 4 minutes over. So I would greatly appreciate some feedback on how to make it more concise and fit within the maximum time frame. So thank you for listening.